Have you voted for any judge or any member of the judiciary ever? No. As far as India is concerned, a judge is what? Appointed. He is not elected. Which means there cannot be too much of arrogation of power into the hands of the people who are not elected by the people. That is the basic premise. Those who have been elected, which means the people, the denizens of the parliament, are supposed to be the ones who have the authority of the people, who represent the will of the people. The ones who don't should not be given too much of power or too much of say into what the law must be. This is the primary difference between the power and the sanctity of a parliament, which is the legislature, the power and sanctity of the executive, which is the government, and the power and sanctity of the judiciary. This is what separates all three in terms of their roles. What is the meaning of judicial activism? What is the meaning of judicial restraint? Let's try and understand this a bit. Creation of the law is not within your domain. Your domain is what? Only interpretation and enforcement, but you cannot make law. You cannot create law. That is the standard assumption that goes with the role of the judiciary. When the judiciary starts making law under the garb of interpreting the law, it is slowly trying to cross that Lakshman Rekha and says, I will also play the role of an executive and I will also play the role of the legislature by making law, by bringing my own personal biases into the decision-making process. When you go to court, what is your standard expectation? The judgment is passed on the basis of the facts before the court. The judgment is passed by the court based on the evidence, sabut, pramana. That is what it goes by. And it is merely trying to apply the framework of the law to the facts of a particular case. And you're basically asking yourself, when I apply these principles of law to a certain factual matrix, to the facts of a certain case, what is the natija? What is the outcome? It is as good or as bad as applying the principles of physics to a certain problem and trying to arrive at a certain solution. It's only a question of application. What does this basically show? It shows that there is a premise that jitne bhi kaanoon hai, they are capable of addressing and they're capable of solving every situation that is presented before the court. That is the understanding, that is the premise. What happens when there is absolutely no guidance before the court for solving a certain problem or for addressing a certain factual situation before it? What is it that the court can do? This is what separates judicial restraint from judicial activism. Judicial restraint means the court remains within the limits that have been circumscribed as far as its role is concerned by the Constitution. And you're simply performing the role of an interpreter, you're simply performing the role of an enforcer. Judicial activism means not only are you interpreting, not only are you enforcing, you're also trying to create laws where there is a certain legal vacuum. It is in that situation that the Supreme Court came about with a brilliant theory saying, I can be accused of judicial activism if there is law and I'm doing something that is contrary to that particular legislation. But when there is no law and I'm trying to address a certain situation, I cannot be accused of going against something. Let's say that the Supreme Court is interpreting a certain legislation which already exists, then it is performing the role that is given to it by a constitution. That is one approach. The second is where there is a legislation, but the legislation still does not address the problems which it is meant to address. That is when the Supreme Court is given certain creative powers under the Constitution to basically craft a solution using that basic legislation as the template. कि ये आपके building blocks हैं, आप इनके basis पे एक solution का इजाद कीजिए. You come out with something to address the situation. The third is the worst possible situation where there is no law at all. And in such a situation, the Supreme Court or any other court for that matter is expected to come out with its own solutions, because you can't go to the court and the court cannot say, I have no solution to your problem. Wherever there is a problem, there is expected to be a remedy. That is the basic mandate of the judiciary. Therefore, judicial activism started off on the premise that where there is no solution and where people do not have access to justice, we must be in a position to do justice regardless of the existence or the absence of a law. That is how judicial activism as a concept came about. It had its origins in such noble intentions. So for instance, one of the finest cases that is cited in the context of judicial activism was of a certain prisoner in the Delhi prisons. His name was Sunil Batra, and he was being tortured by the warden on a regular basis. He was being physically abused on a regular basis. He had no way out. There was no way that he could do anything about it. So this gentleman writes a letter to the Chief Justice of the Supreme Court saying, I may be a prisoner, that does not mean my dignity can be taken for granted within the prison. So kindly help me. A letter became a petition. Usually when you go to court, what is your assumption? That you will file a long-winded case. You will file formal pleadings. You will basically go through a huge process of procedure and whatnot. You'll be stuck in the rigmarole of procedure. So the Supreme Court said, no, let's do something different. Even letters can be treated as petitions in appropriate cases where the person is not in a position to approach the court, or where the person does not have the means to engage a proper representation or a proper advocate before the court. This is how the concept of judicial activism began in the 1970s as far as India is concerned. But for the last few years, the Supreme Court has found itself in the limelight and in the headlines for all the wrong reasons. The Supreme Court has taken upon itself the responsibility of setting right every wrong in public life. Meaning thereby, the Supreme Court today interferes with the aspect of governance, it interferes with the aspect of administration, it interferes with every aspect which is within the sole preserve of the executive, meaning the government. How did this come about? Is this desirable? This is the basic question that we have to ask ourselves. The basic rules of interpretation of a certain constitutional provision require the Supreme Court to do this. Your job is to understand the provision as it exists and you simply apply it to the facts of a case. If the language is unclear, then you try and look for the context or the sandarbh in which that particular provision was actually promulgated, saying iska actual meaning kya hai. Despite which, if you're not able to arrive at a certain conclusion that this is the manner in which this provision is supposed to be read, then you apply what is known as the purposive construction. Saying, okay, I don't think I can make sense of the provision as it exists. So let me see what is the best possible outcome that I can arrive at based on my own purposive reading of this provision. In doing so, what the Supreme Court is supposed to do, when this provision was crafted, this was the intention behind the crafting of the certain provision, and therefore I will interpret it in a manner which advances that particular objective. Let me give you a simple example. So there is this legislation that goes by the name the Representation of Peoples Act. And that legislation is what governs people who are elected. अगर आपको लगता है कि election के time पे कुछ घपला हुआ है, or if that person has resorted to some kind of electoral malpractice, or he has done something wrong, that is the legislation under which you approach the court for relief, saying his election is fundamentally fraudulent, it is fundamentally flawed, and therefore he should not be given that particular position, and his election must be treated as being disqualified. That is the provision under which you go. Now, the Supreme Court had an opportunity to interpret certain provisions of this legislation, and the question before the court was this: can I, as an elected representative, refer to religion, caste, language, or any ethnic identity to get votes from people? This was the question before the Supreme Court. The question was, can I use individual identities to come out with or to make a mass appeal to my electorate? How many of you have heard of the anti-Sikh riots of 1984? So today, if I were to contest an election basically saying, please vote for me regardless of which religion I come from, and I will make it a point to prosecute these people and bring them to the book and put them behind bars. If I were to make this particular statement, use your common sense and tell me, does this seem wrong to you? Does it? It doesn't. The Supreme Court has basically held that doing even this is wrong. According to the Supreme Court, all references to religion, caste, language, ethnicity must be completely removed from any kind of election campaign. It may seem like a great idea, it may seem like a wonderful concept, but that is not how we operate in reality. If you remove all references to identities from any kind of election campaign, then what are you going to fight an election campaign on? Only development? Are there no issues that concern the population other than development? From being a mere interpreter and enforcer of the law as passed by the legislature, today the judiciary has taken upon itself the role of a social reformer. The judiciary has basically taken upon itself to actually cleanse the society of all evils possible. This is not the role of the judiciary. The judiciary is merely supposed to perform a very, very simple function. Are the laws which are passed by the parliament consistent with the constitution? If the answer is a yes, then you simply give effect to that particular law and you ensure that your outcomes are not inconsistent with or at loggerheads with the original intention of the Constitution. Today, what the Supreme Court is doing is this. If a certain legislation says all crows are supposed to be black, let's assume for a moment that is the example and that is what the legislation says. In the purpose of interpreting and in the purpose of social activism, the Supreme Court has pushed it to a point where it is asking itself, can a crow ever be black? It has basically come out with conclusions and reasoning which is directly at loggerheads with the original intention of the legislature. What happens because of this? It leads to a situation where a handful of people who are not elected by the people, who are not elected by the electorate, who are not elected by the citizens of this country, arrogate to themselves the power to decide your destiny, arrogate to themselves the power to decide what is good for you and what is bad for you. This is what the Supreme Court has done. How many of you are aware of how Supreme Court judges are appointed in this country? There is a provision of the Constitution which is Article 124, which basically says that judges of the Supreme Court shall be appointed by the President in consultation with the Chief Justice of the Supreme Court. So according to you, what does common sense say? Who makes the appointment? It is the President. But he will seek the counsel of the Chief Justice. This is the plain and simple interpretation. You won't believe it. There are at least 3 landmark judgments where the Supreme Court has decided that the power of actually appointing judges rests with the Chief Justice and not with the President. Which means it has become one of those elite gymkhanas where the member of that particular club shall decide who shall join it. Who appoints the Chief Justice of the United States? The President. It is a political appointment at the end of the day. Here is a situation where the Supreme Court is basically saying that we will decide who shall be part of this elite club. There can be no say from the executive as far as this particular appointment is concerned. I'll tell you what are the consequences of this. Agar aapko kisi government se takleef hai, what do? In the next election, you at least vote it out of power. You have the option of voting the opposition into power. That is how you teach a lesson to a party which is in power, which does not do what is expected of it. But if you don't agree with what a judge does, can you do something about it? Can you do anything about it at all? Therefore, what does this take you to? An elected representative can at least be held accountable in some fashion, in some manner, through some process, and he can also be chucked out of power in the next possible opportunity, which is the next election. But you can't do that with a judge. There have been rarely 1 or 2 instances in the history of this country where even proceedings for impeachment of a judge has been initiated. You cannot terminate the appointment of a judge without actually setting in motion an impeachment process. It is as stringent, as complicated as the impeachment of the president of a country. Someone who is not accountable, someone who cannot be removed from power until he retires from the particular position, someone who does not have to wait for the next possible election, has taken upon himself the role that is basically meant for the executive. That is the problem with judicial activism. Judicial activism results in people who are unelected arrogating power to themselves with absolutely no semblance of accountability or transparency to the basic electorate. This is what it results in. It's possible for any of us to actually comment against any politician. I've seen a number of articles being written against Modi. We have seen a number of articles written against any of these elected representatives. Do you see any article written against any judge of any court? Have you seen any article written against any Supreme Court judge or a High Court judge or a District Court judge? Do you see that happening as frequently? Why do you think that happens? Any reason? So you have the Contempt of Courts Act, which shields courts and judges from any kind of criticism. You are not voted to power, therefore you are not answerable to the citizens of this country. You continue to be in your position until you retire. The only way that you can be shown the door is either through an impeachment process, which is as complicated as that of the president of this country. You cannot also be criticized because there is a Contempt of Courts Act. And you have taken upon yourself the responsibility of interfering with every aspect of public life, every aspect of private life. Ask yourself, does this sit well with the basic concept of democracy? How is this different from an oligarchy? How is this different from a monarchy? How is this different from a situation where the person who wields the power to dictate outcomes in every aspect of your life is shielded from criticism and cannot be shown the door. This is what happens when the judiciary results or when the judiciary transgresses its limits. But you also have to ask yourself, if the government was as corrupt as what it was between 2004 and 2014, which is perhaps one of the most corrupt governments in the history of this country ever, or perhaps in the world, and people have to suffer the presence of the government until the next election, what do you and I do as a common man? What do you immediately think of? You say, if these people don't listen to us, we'll rush to court. That is basically the tendency of the common person to say, if I don't get justice from other arms of the state or from other wings of the state, I can hope for justice from at least one place, which is the courts of law. Therefore, it is possible for somebody to say, please understand that judicial activism is the consequence of corruption in the executive and complete loss of faith in the parliament. If the executive had done its job and the parliament had done its job, which means the legislature and the executive had executed their responsibilities properly, there would have been no occasion for the judiciary to overstep its boundaries. That is the logic that the other side gives. This is the other point of view, saying every effect has a certain cause. And the reason for judicial activism is that the executive and the parliament have thrown the country to dogs and they're not doing what they're supposed to do. Therefore, the only place that a common man can get justice from is the court of law. It is possible for the Supreme Court or any of these courts to turn around and say, please tell me, how are you holding us responsible? We form a part of the state, we are an arm of the state, we are a wing of the state. Are you asking us to turn a blind eye to the circumstances and conditions of the people when the other arms of the state are not performing their responsibility? That is the basic question that you get from the Supreme Court to justify its judicial activism. So if you were to look at it from a philosophical standpoint, judicial activism is the result of executive and legislative apathy. Therefore, the balance had to be set right, which is why the Supreme Court stepped into the picture and say, if you guys do not do your jobs, I will try and do something about it. And I will do something about it through the Constitution. But it has now come to a point where the balance has completely gone the other way, where the Supreme Court is now interfering with the functioning of sports bodies. It is interfering with the functioning of religious bodies. It is interfering with the functioning of every department. There is a possibility that we may ask ourselves, what then is the solution? How do you get out of this quagmire? If, let's say, you were in the United States of America and you have a problem with the Municipal Corporation of New York, let's assume that is the case. What do you think happens in that country? Today, if you have a problem with the Municipal Corporation of Delhi and you believe that it is not doing its job and that there is a state of filth around you only because these people are neglecting their duties, do you have a legal course of action to hold them responsible today? What is the common sense answer that comes to your mind? Can you take any of these people to courts? It is possible for you to take them to courts, but you do not have a legislation that basically holds them accountable. In the United States and other jurisdictions, what happens is, you have laws which envisage class action suits against government authorities, which enable you to get compensation or damages for the harm that you have suffered as a consequence of negligence of duty by a state authority. We don't have any of those mechanisms in this country. Consequently, what happens is, since you're not satisfied by one arm of the state, you end up piling on the other arm of the state, which is the judiciary. If, let's say, I have a problem with a certain practice as it exists today, and that practice has some kind of religious sanction and has some kind of religious basis, then the state or the parliament has to basically come out with a law saying, you may have a certain religious right. However, in the interest of public policy and in the interest of individual right to life, to give respect to the dignity of an individual, I will pass a law which basically abolishes this practice. That is the power that has been given to the state. In the absence of any such law, can the judiciary take cognizance of this on its own? Even if there is absolutely no legislation that governs a certain practice, I, as the Supreme Court, have been given the responsibility of not just enforcing law, but also of protecting rights. And therefore, even in the absence of a legislation, I will take upon myself the responsibility of striking this balance between the individual right to life and the religious rights. And if I deem it fit, I will abolish this practice. This is how the Supreme Court has basically gone about expanding the scope of its own duties, its own obligations, its own mandate. Therefore, what you have to understand is this: judicial activism is the consequence of apathy on behalf of other arms of the state. But it has come to a point where the judiciary today has expanded the scope of its inquiry into practically every aspect of life. Across the world, in civilized democracies and in civilized jurisdictions which have similar histories as India in terms of our judicial traditions, judges have been expected to play a very conservative role, and they've been expected to play a very minimal role simply because they cannot be held to account like elected representatives. This is what you need to understand. The problem with judicial activism is that there is no sense of accountability. There is no way that you can hold any of these people to account, nor can you actually express dissatisfaction, because there is always the sword of contempt of court that is acting on your head that prevents you from making any statement against any judge or any court. Therefore, to sum up, judicial activism was perhaps the need of the time when there was severe executive apathy and when people were under the impression that reach to courts of law is beyond their means. That particular phase has now gone, and I would certainly say between the 70s and the 2000s and 2017 that we are in today, awareness of people in terms of their legal rights has improved a lot. Therefore, it is time for the judiciary to take a step back and ask itself the simple question: am I expected to perform this overarching role of a big brother even today, when there are other arms of the state and other wings of the state which are better off and which can do what I can do with the mandate of the people? Too much of reliance on courts to do or to solve your problems has led to a very bad thing as far as democracy itself is concerned, which is citizen activism to help yourself has come down. You rush to court each time you see a problem, but other than rushing to the court, what kind of steps have you taken to put pressure on your elected representative? Bill Clinton, I think, was found jogging in a park. And each time he was found jogging in a park, there would be a huge posse of bodyguards and security persons going along with him, which intimidated other users of the park. This was while he was still the president. People who were practically nobody compared to the president of the United States and average citizens decided to make an appeal saying, you have a huge house called the White House. It has a fantastic lawn. Dodna hai to wahan pe jaake dod lo. Please don't come and do this here, because it causes a lot of trouble for us as average citizens. Ask yourself how many people in this country can have the guts to make a similar statement to any person in any power. Forget for a moment the Prime Minister of the country is always the most targeted person today. Other than the Prime Minister of the country, which other person can you make the statement to? Try making the statement to a simple bureaucrat who is a civil servant. You can't make the statement. Two, it also shows that while we are a democracy on paper and we function as a democracy on paper, it is still a feudal mindset in our heads that anybody who is in a position of power has the right to lord over the commoner. This is the question of attitude that needs to change, which means you must have the guts and the ability to hold the executive by the scruff of its collar and ask uncomfortable questions, and you must have the ability to get a concrete relief out of it. Only when you do this, you will stop vesting too much of power in the hands of the judiciary to solve all your problems. That, I think, is the way forward. Unless and until you actually start thinking on these lines, the tendency to continue putting all your eggs in the judicial basket will continue. Evolve a national consensus among the citizens that the Supreme Court cannot decide its own appointments. The more you have a chorus or a clamor for this kind of an approach from the general public, it is going to be hard for their lordships to actually not pay attention to it. We have to start putting faith in the ability of the common public to voice its opinions. But for that, it's a complicated topic that needs to be broken down to a common man's understanding. I am struggling to break this down to an educated audience. Imagine if you can try and break this down to someone who is in some part of Haryana or some part of Tamil Nadu or some remote part of Andhra Pradesh. You will struggle with it. They'll say, how do I care how these people are appointed? It does not figure in their list of priorities. The executive may not have complete say or need not have the sole say as far as appointments are concerned. But to say that elected representatives cannot have any role or any say whatsoever in the appointment of judges to the highest court of the land would be, I think, a bit too much. It would be a stretch of an argument to make. In the United States, although the Chief Justice of the United States Supreme Court is appointed by the President of the United States, it's not as if his government is let off the hook by that particular judge or by the Supreme Court under his stewardship. On a regular basis, actions are filed against the government during the tenure of the government and during the tenure of the particular president. So you have no other option but to put faith in it. Nobody has come out with a solution which is entirely foolproof in terms of political influence. Or to say, how do you shield the appointment of let's say the Chief Justice or anybody from any kind of political bias? इसका तो आज तक किसी के पास कोई comprehensive जवाब है ही नहीं. And most people have basically said, from the judiciary, if you have at least 2 or 3 people on a panel, have one member from the state, and his opinion need not be binding, but let him at least have the power of veto. As opposed to saying that his word will be the last word, let him at least have the power of veto. Just take a look at the constitution of the NJAC. Whether you completely agree with that particular constitution or the manner in which it sets up the panel, it at least gives you a framework to build over and to build upon. You have to choose between 2 situations. One, where they themselves elect who shall be their successors. If that is not desirable, then what is the alternative? The alternative is to have somebody else have some kind of say in this appointment. That's the only way to go about it. Can you theoretically and practically rule out that person or his party from ever being before the court who he has appointed? You can't. See, there is a principle of law and there is a principle of judiciary which says justice must not only be done, it must also be seen to be done. So that is where your question is coming from. How do you prevent these questions from arising in the mind of the common public? अरे भाई इनको अगर इन्होंने अपॉइंट किया है तो इनके खिलाफ कोई वर्डिक्ट थोड़ी आएगी. That is the basic question that everybody has. Unfortunately, I can't think of a better solution. There is a paucity of solutions as far as this issue is concerned, or at least I am not able to think of it. You have bad, worse and worst, and this is perhaps bad. There was a journalist who basically wrote repeated articles in the Times of India with respect to a judge who never came to the court on time and who would always be at least 1.5 to 2 hours late. At least that was his version of the judge's conduct, a Supreme Court judge. Whether you respect Times of India as a publication or not, at least this gentleman is fairly vocal in his opinions. So he wrote about it. And he was then hauled up in court saying, how dare you comment on this? Because it reduces the confidence of the people in the court when you say these things about the court. Nobody focused on the fact that perhaps the conduct of arriving late in court was reducing the confidence of people in court, not the article. Between the two, a court functions for only 6 to 7 hours a day. 10 to 1, 2 to 4:30 or 5, that's it. So effectively it's only for 6 hours. Assume you come 1 hour or 2 hours late even in that. You have vacations in between for winter and summer, for Holi, for Shivratri, for everything. It's almost like a school in that sense. No wonder you have this kind of pendency in courts, right? So this gentleman was issued a notice. He had to go and tender an apology and all that.